The information contained in this video is distributed free of charge for educational purposes. Whilst we have taken all reasonable steps to ensure that the information contained herein is correct and up to date, insofar as the law in South Africa is concerned, the law remains a nuanced and complex field of study, replete with many exceptions and conditions. Please, therefore, do not utilize this information as legal advice, which it is not. When in doubt, consult with a legal professional. For more information, please feel free to contact our offices. Very, very warm welcome to all of you to today's meeting. I really do look forward to chatting and conversing with all of you. Today is a bit of a new concept and a new idea for me. As some of you may know, I've been doing these webinars for a while. However, today I thought, let me do something a little bit different. And the thinking for doing something a little bit different came from this quote, that knowledge is power. Knowledge shared is power multiplied. And whilst I have a specific skill set that I can share with you, there are others out there with extremely important other skill sets. And for that reason, I've got some lovely folks chatting with me this morning and sharing quite a lot of interesting information with you guys, and obviously with myself as well. And I'll introduce them to you a little bit later on. Before we get into the program formally, let's just go through some house rules and etiquette. For those of you who registered by LinkedIn and would like to utilize this as an opportunity, or even some of those who registered via our website for networking, and if you are open to networking with some of the other members of this chat today, please do feel free to use the chat bar. Put in your name, your contact details, and what you do. And obviously, some of our other attendees can get in touch with you throughout the course of the session, or after all, hopefully not throughout the course of the session, because they're going to be listening to our wonderful panel members today. A lot of you have registered via LinkedIn, so I do not have any of your contact details, and that's perfectly fine. However, if you would like to jump on top of my mailing list, to be informed of new developments in the law and or webinars coming up, please do just pop us a message with your email address, and I will distribute those to you as well. I do assure you that we try to keep the spam as low as possible in terms of these initiatives. Right, so house rules and etiquette, we like to know who we're dealing with, so please use your real name. Just so we can see who's in and who's not. It is a bit difficult keeping a straight face answering someone with a name of Superman 5728 or Pixie Fairy 39, which was an interesting one. So guys, for purposes of the tone of today's webinar, divorce does happen. We do intend to deal with this extremely sensitive and emotive topic with dignity, yet we also do intend to deal with it realistically. That is going to be the tone of today's discussion. Please note, guys, this is not going to be how to bullshit your ex-spouse 101. We're not going to teach you how to hide assets, and this is not the purpose of today's discussion. But we must acknowledge that there is case law which Sine is going to be dealing with us, sharing with us a little bit later, which has some pitfalls. If you have a trust, if you have a will, there are implications to these bona fide estate planning tools that we do need to be aware of. We have a large group today. I see we're about 37 people in the meeting so far. We've got over 100 registered attendees. So if everyone does show up, and we do allow raise hand and chipping in, it is going to be very chaotic. So I'm going to ask, please type your questions or comments in the chat box. I've got my lovely director, Shantae, and I call her lovely because she does most of the work in the family law department, so I get to chat to you guys. So thank you, Shantae. She is going to be fielding some of the questions as they come in. those questions that are a quick answer, she's going to answer on the fly. The remainder, she's going to pass on to our panel members to answer a little bit later. In terms of the tone, in terms of what is required and requested of our attendees, we do welcome respectful discussion, dissent, and comments. None of us sitting today talking to you do profess to know absolutely everything. We are all professionals in our field, but no one knows everything. So if you have something interesting that you can add to the discussion or a different point of view, which we might not have raised, please feel free to put it in the comment box. We all have a lot of info to share with one another. As I said earlier, knowledge shared is power multiplied. Please, guys, keep discussion respectful and avoid hate speech, victimization, or belittling attendees. We are all here to learn. Most of all, myself, this was a nice opportunity to leech off the superior knowledge of colleagues under the guise of them teaching you guys. But meanwhile, I'm sitting here learning a ton of information from them as well. I have Quinn specifically looking out for hate speech and that sort of thing. Any inappropriate, derisive, disrespectful comments will lead to the participant being removed from the discussion immediately. Guys, please do not record the sessions or distribute the content to people who didn't attend. We will be recording it and we will make it available for those who'd like to recap a little bit later. However, we do spend a hell of a lot of time developing these courses and other webinars for the benefit of all of you who attend and others who may attend in future. But unfortunately, piracy and unlawful distribution really does impede our ability to feasibly do this again. So do not fret. You will get copies of all of this information in terms of the names of our presenters, their contact details, as well as the information and the recording of the information presented. Right, so without further ado, folks, I do these webinars for two reasons. Number one, I absolutely love sharing knowledge and I do love learning. Number two, I love expanding my network even more. So I've got two things over there, my business card, which you can scan with your cell phone if you'd like, or you can connect with me on LinkedIn. Please do. I'm always open for a cup of coffee. I am a coffeeholic. If you would like to connect with one of my panel members today, please reach out via the chat bar and we will obviously convey that to them and they will be in touch with you to set up a meet and greet. So, without any further ado, let me introduce you to my very distinguished yet very naughty panel of experts. None of us are academics or professors. We are all people, working dogs like most of you. We are all working in the industry in different capacities. My name is Mervyn Vermeulen. I'm an attorney. I specialize in divorce and I will be moderating today's discussion and ensuring that none of our panel members reach any fisticuffs in the event of disagreement. I will also be making sure that we stick to our time limits. We've got a heck of a lot of information to go through. Then moving from left to right in no particular order of importance and or stature and or gender or language or cultural upbringing. Our first, someone is sharing their screen with me. Please do not hijack my meeting. Thank you very much kindly. I'm going to throw down my mic if I have access to a mic. Right, so let's go back to slide 5. On that note, Theresa Luyt, Mediation Network. Theresa is a mediator in active practice. She's based on the West Rand of Johannesburg, and she is also a certified financial planner, although she is non-practicing. I've asked Theresa to join us to specifically talk about the manner in which she, as a mediator, has managed to use estate planning tools and knowledge to the advantage of her mediating parties. Then, second, hello, Theresa. Nice to see you. Thank you for waving. Then I've got Seugnette Schwim. She is from Wealth Succession as well as from Schwim Venter Incorporated. Seugnette is also an attorney. She specializes in estate planning and wealth structuring. I've asked Seugnette to join us today to specifically speak about pre-divorce estate planning. Issues such as you have a trust, it is a legitimate trust. Is your trust properly set up? Have you got safeguards in place that a court won't dismiss it as an alter ego or as a sham, etc.? Seugnette is also going to be talking to us a little bit about wills and basically, in a nutshell, conducting your affairs during a marriage, not in anticipation of a divorce. No one anticipates getting divorced, but in case of a divorce. None of us want to be in a car accident, yet we all have short-term insurance, hopefully. And then last but certainly not least, Mr. Jacques Theron. He is from 212 Bluestar. He is a certified financial planner. Jacques is going to be speaking to us about the introduction. What exactly is estate planning? What do we talk about when we talk about things like estate planning, retirement planning? What's the difference between long-term and short-term insurance, etc., etc.? And I see Jacques looking very concerned, being like, well, you didn't tell me I have to talk about this. But Jacques, thank you so much for joining us. I really do look forward to hearing from you. And just before my voice gets extremely tired, just the format of today, folks. The formal portion of today's discussion is not going to be more than an hour and a half, whereafter we're going to take a short break and then we can go into questions and answers just because of the large group that we have today. So we're going to do, in terms of each topic, today we're talking about 3 topics. Number 1, what is estate planning? Number 2, pre-divorce estate planning, and thirdly, post-divorce estate planning, which I've earmarked to a panel member each. We will be going through about 15 minutes of introduction, whereafter we're going into 15 minutes of discussion between our panel members and myself. If anything comes up, for those who joined the meeting a little bit later, please do type your questions in the comment box. We will do our absolute utmost to deal with all of the questions throughout the course of today's webinar. So, guys, on that note, thank you once again for taking the time out of your Friday morning to sit with us, to learn with us, to spend some time with us. And I hope you are as stoked as I am to hear these extremely interesting individuals talk to us about their expertise. In closing, guys, Theresa, Jacques, Seugnette, thank you for taking time out of your busy schedules to help me to present today's webinar. I really, really do appreciate it. And on that note, let's talk about what is estate planning. And I'm going to ask Jacques to give us a little bit of an introduction. Guys, this webinar does presuppose that you know what is in community of property, what is out of community of property, and what is an accrual. Right. Excellent. Jacques, take it away.
Well, thank you, Mervyn. Thank you to all of our guests and attendees. It's really fantastic to see such a beautiful turnout. And I've just warned everybody that Mervyn said, just come sit with us on a Friday morning. We'll have a nice quiet chat. And then he surprises us by having 34 online guests so far. Thank you, Mervyn. I really appreciate that. And it's lovely to be put on the spot. And I'm sure we'll make you proud from that side. So good morning, everybody. And it's lovely to have a chat around estate planning. It's really quite an interesting field in terms of what happens from a financial planner's perspective. But I thought, let me step a little bit back, and I'd rather maybe just clarify 1 or 2 items for you, just to kind of put it in space so you understand where estate planning fits into the major financial planning theme. So let's start off by talking about what is financial planning. I mean, everybody's heard about a financial planner or a financial advisor and what it is that they do, or what it is that we think that they do. So let me start off by just giving a very basic outline of what financial planning should be. So financial planning really involves looking at a client and his spouse's complete financial picture. I mean, here we talk about holistically looking at the complete picture. And then in a very ethical way, start advising them on how to achieve both their short-term and long-term goals that they've set for themselves from a financial perspective. I mean, this could entail anything from looking at savings, looking at retirement savings, looking at any of those elements relating to taxes, looking to risks that they might have, the way we can look at helping them cover some of their financial risks. Ultimately, we talk about a competent financial planner will build a very strong and a valuable relationship with the client and walk with them through this path, and ultimately give the client confidence in terms of what they have today, as well as helping them to develop their roadmap for the future. So that's financial planning as a total. Then behind that, Mervyn, I see you've mentioned that we need to talk around risk versus investments. So let's talk around now. So what is risk planning? So risk planning is a process of planning for any unforeseen events. Exactly what you were saying earlier, Mervyn. Nobody wants to have a car accident, but we all have insurance, short-term insurance, just in case it does happen. So with an unforeseen event from a financial planning perspective, we'll look at things like death, disability, severe illness, impacting the breadwinner's ability or the business owner's ability to be able to generate an income for them, their family, their nearest loved ones. So I always like to call this the if this, then that type of element that you need to understand. So if this happens to you, then your insurance company will give you that amount of money. So it's really quite simple from that perspective. Next step behind that is, what is investment planning? Well, I think this is probably more easier thing for people to understand. Investment planning is really a very core component in the financial planning area. We as financial planners will help the clients set out and measure their goals for what it is that they want to save for. So what is a suitable mix of products? Are the products tax friendly? Are the products matched to what the client goals is in terms of short-term, long-term investments? Are we starting to put money together for your retirement? What is the specific goals around that? Ultimately helping to take those elements and create a wealth creation strategy for the client to seek a favorable outcome in the future. So now we start getting into the interesting bits, estate planning. Estate planning is also a very big component in terms of general financial planning. Now, exactly what Mervyn said before, I am a certified financial planner, and I have a very good working knowledge about estate planning around some of these elements. But as a financial planner, I'm not an expert in this arena. So I will even I will go to somebody like Seugnette and discuss this with her to be able to give the client the best advice feasible. So now we need to understand what is the difference between estate planners and financial planners. So my space as a financial planner is to help the clients clarify the client's existing options, recommend products, recommend investments, recommend strategies to help them achieve their financial goals that we mentioned before. Then, while the estate planning is a competency within my skill set, we have to go to an estate planning attorney or an estate planning professional so that they can help us ensure that the client's assets are properly organized and protected during their lifetime, as well as creating a plan. What happens if you get incapacitated, or we create the what if scenarios. So good estate planning is around planning for as many what ifs as possible without being ridiculous behind this. So I hope this helps put us in space with this, Mervyn. Yeah, that's, I think, is hopefully a nice startup for us on this.
Fantastic. Thanks, Jacques. Look, I think there's one or two things I would love to clarify from you, and I am but a mere litigation attorney, so please do forgive my ignorance. One of the big questions that we are often asked, and I want to throw this open to you, Jacques, firstly, And thereafter to one of our other panel members, if you guys can just raise hand function if you want to add something to it, is we often have to, in divorces, distribute to the parties lists of assets and liabilities. And under the assets, we invariably get someone saying, I have a life insurance policy, and that is now an asset. And I said, but is it really an asset? But they say, no, but my wife or my husband or my son or my daughter or whomever is the beneficiary of that policy. So I think one of the first starting points is, which of these aspects fall within one's estate and which ones fall without?
Well, Mervyn, very good question. And I've actually had a few of my clients ask similar questions to that. People tend to think that a life insurance policy has an intrinsic value. And the only time it has an actual value is when somebody has passed away. That is when it starts having a value. So only at that moment, at that time in law, is it deemed to be an asset. So when we're doing an actual deceased estate or something like this, it's classified as what they call a deemed asset. So it's not a physical asset, but it becomes an asset in the event of somebody passing away. Where it does have a massive impact in terms of estate planning, and especially from the divorce side, is if the estate plan that we've set up is there to cater for specific for children or cater for spouses or cater for specific requirements, and people decide to cancel them, and then you might not be able to achieve those requirements going forward. So we would have to look at those types of plans and understand what the meaning was behind that life insurance policy as an example, to understand what the impact is in a divorce type of scenario.
Absolutely. That's a very, very important point. Seugnette, I see you've got something to add.
Yes, so that actually, and Jacques, thank you so much for the great introduction in estate planning. And it is really such a big field and so many moving parts to it. And to actually crack it down in a couple of hours is an impossible task. But as these questions comes up, it's great to have an open discussion. So to answer, to add to what Jacques just said, and to try to our view of what is included in an estate and what is excluded, is to understand that your assets typically fall into one of four categories, both offshore and locally. So family wealth at least falls into one of four categories. So you either have your trust assets, you've got assets in your own name, which is your estate assets, and that is where we come into the will and look at the divorce actions. Then you've got assets in companies and corporations, and of course, the shareholding of that is either held in your own estate or in a trust, but it's kept in a different bucket of assets because different rules apply to it, shareholders agreements, the Companies Act, and so forth. So that needs to be seen in a vacuum. And then finally, pension and life insurance that Jacques just talked about is a separate set of assets. So although these four classes or buckets of assets have interchangeable components where they do affect each other, people and families have to remember that they are all dealt with in terms of separate documentation, whether it's a trust deed or a will or a Companies Act or a memorandum of incorporation, and then how it is dealt with within that bucket can then point back to another silo or bucket of assets. So, for example, for the life insurance bit of it, exactly what Jacques said, a life insurance, as a beneficiary in life insurance, you don't even have the hopes of receiving anything, because the product actually, or the value, only triggers as the date of death. So while that person is still alive, there's nothing to it. It's just a document, a contract. An exclusion to that, perhaps, and that can also be open to debate possibly on another forum, is, for example, an endowment product where it's an investment linked with a life insurance. But depending on how it's structured, it may be that the estate owner has access to those funds at least once during the term for which it was set up. And the moment we're talking about endowments and they've got access and control, then we say, but wait a second, actually this falls into my second bucket of assets, and now I want my spouse to know about this or keep it into consideration. So I think everyone should just categorize the assets and then understand how they work with each other.
Mervyn, you're muted.
I'm muted because I'm flabbergasted. You know, as a humble litigation attorney, which I've said previously, it's very very interesting to go into these waters. And something extremely interesting, which I also want to just throw out to our viewers today, when we talk about divorce settlements, we must always make provision for those things. And we'll talk a little bit about it in terms of estate planning and divorce. But for those who are not yet putting in a clause in their divorce settlement agreement to say that this agreement is binding on the executor of the deceased estate, you are really setting your client up for quite a lot of failure if one of the parties do predecease. And I suppose, Sine, to add to your point, that's where these things would really come into play, because you have these risk policies which presupposes the death of one of the parties. Now you have a divorce settlement agreement, and then one of the parties sadly passes away. And then all of a sudden, you're dealing with not just a divorce settlement, but you're also dealing with a deceased estate. And if the will hasn't been amended, you're dealing with a will and all sorts of things. And I'm sure our viewers can very, very quickly see why I have very little appetite to play in your realm, Sune. So very, very interesting concept about the buckets, and I'm going to ask you to also elucidate on that a little bit more when we get to your slide of pre-divorce estate planning. So thank you for that. Jacques, what's your thoughts in terms of the whole bucket theory in terms of estate planning?
Mervyn, it really simplifies the classification of assets. You have to, and exactly what Sunay said before, each one of those assets has such a specific set of rules behind it. And as much as we want to say that all buckets count for every person and every situation, they don't. Because every partnership in the event of a divorce is ultimately unique because of their combination of those four buckets that they've used. But it becomes super critical to understand what those buckets are, what the impact of those buckets are, and then how, from a divorce perspective, we want to apply that. And I think Theresa will talk about that a bit further from the mediation side, about how we mediate to get the best out of that. Now, unfortunately, I think that a lot of times when there's a divorce on the table, there's a huge amount of emotion wrapped up in this. And it's our role as the professionals in this type of case to take the emotion out of it and reduce it to simple yes, no answers, or a simple set of numbers that makes it easy for us to carry on and move on with the process.
Absolutely. I think that really is the nub of it, isn't it? That you cannot use a cookie cutter approach when you deal with families. They are extremely unique and bespoke units. And I must be honest, and it's not to pander to any of my panel members today, but I am very fond of working with financial advisors and financial planners when it comes to divorce, because there is an understanding of the actual workings of the financial aspects which one simply cannot necessarily as an attorney have. And I think, you know, on that note, you know, I'd love to defer to you, Theresa. I see your hand is up in any event. So let's hear from you. And I'd also love to hear from you in terms of your CFP experience as a mediator in mediation. Theresa, you're muted. You haven't spoken too much yet. I'm not going to mute you just yet, hey?
Yeah, you always say that. Thanks, Mervyn, and thank you for this opportunity. And I must say, I am also very humbled by everybody that's actually on this call and are part of this conversation, because this is what it is. It's a conversation. And in that matter, I want to say this is the thing that mediators challenge us. The attorney and the financial advisor sees them slightly emotional because they are planning for the future. But in my experience, the moment a couple with a divorce walks through my boardroom doors, those four buckets becomes one big tsunami. and they actually do not distinguish between buckets. And for me, it is actually very, very helpful as having a little bit of a background in terms of financial planning, and also very slightly in training in estate planning. I say that with huge humility, okay, because it's a huge field actually. I find it very helpful to be able to get those emotion away from someone. I mean, trauma teaches you that the first thing you address is a timeline and facts. And bringing those facts that a financial planner and a proper estate planner can give you, and the background they can give you, can actually disignite a situation for you. I mean, we use facts in an emotional way to actually pull us out of our reptile brain back into prefrontal cortex. So I want to say to mediators, listen to what they're saying, because these facts and these tools are quite important. The other thing, Jacques, I think that you also just need to address as well is the moment financial instruments, for instance, comes into play, clients often do not distinguish in terms of Seunette's bucket thing, what is in the bucket for the divorce, in the estate bucket, in other words, and what is in the trust bucket, and what is actually none of this. This is retirement planning, because the retirement bucket is a middle one, because there you have pension funds that can fall within the estate, and you've got certain elements that can't. Please.
So, Theresa, immediately you've just made the complex subject a lot more complex. So, well done.
Sorry.
No, and you are absolutely correct by that. I have seen, just even talking to clients, just when you're talking about normal retirement planning without bringing a divorce into this, people have a very different understanding of what the rules and laws are around specific instruments. Let's use a pension fund as an example. Because a pension fund has certain things that it allows for tax saving during the time that you're building it up, to be able to, when you retire, give you a nice lump sum and ultimately produce an income. When there's a divorce behind that, I mean, you're absolutely right. It becomes, I want to use the word money grab, even though that's probably the wrong term to use, but it becomes a source of funds that people just want to grab onto. It really is super critical for somebody like myself or somebody like Seugnette to be able to step in there and help people just understand the rules around that. So I spend a lot of time with my clients educating them when we're doing financial planning or the basic estate planning for them before we go to Seugnette, is to teach them what each of those buckets are good for, what they mean to them, and what the implications are behind them.
Absolutely, that's such an important point that you made, Jacques. Especially, you know, in terms of the tax. I know Shantae just settled a divorce last week or the week before, where the one party has to buy out a portion of the other party's share in the movable property. It's an accrual marriage, and they're utilizing the pension fund payout for that, you know. And I see you shaking your head, and I think that's something very, very important, considering that we've got a lot of mediators in here. Obviously, I gather from what you've said, if you pay out your pension fund at divorce. Now, for those who are not aware, when you have a divorce and a pension fund is deemed to be an asset and it is divided, we'll look at the pitfalls around the wording later, ladies and gentlemen. Don't fret. We are opening that can of worms. One of the options to the non-member spouse that gets an allocation is either, obviously, to utilize the funds in cash versus investing it in a qualifying fund. Now, I know the tax implications of that is something that you looked at in quite a bit of detail in preparation for today. And I would actually, from someone going into a roundtable conference to negotiate a divorce, love to find out from you what prejudice is there in terms of utilizing cash rather than reinvesting in another fund.
So, Mervyn, you need to understand, SARS loves divorce cases. And SARS is the one thing that we just can't get away with. They are sharpening up the rules, and SARS is the only organization that changes the rules of the game to make sure that they win the next round. So, very simply put, if a spouse takes their money out of the fund, SARS is in their first thing to take their withdrawal benefit. Yeah, so the spouse will get 25,000 Rand tax-free. After that, it quickly escalates to 36%. So just generally talk to your clients that they're going to be paying 36% tax on that money coming out, because that realistically is potentially where they'll end up. Then, not only does that happen with you drawing the money out today, when that client then retires in 20, 30, 40 years or 5 years from today, that money that they've drawn out of that fund in a settlement is held against them in terms of their lump sum that they are able to withdraw at retirement. So they get a double whammy. And if the client's also been unlucky in their life to have been retrenched in between all of this as well, they get a triple whammy from SARS' side. So it's key to try and explain to people that even if there's a pension fund and it looks like there's money available in that fund, that money actually is earmarked for your retirement. And even if it's part of a settlement, use that as your portion of what your retirement would have been with that partner that you are now leaving. So ultimately, try and retain as far as humanly possible those funds inside of another retirement product, which means we can transfer it out of the partner's pension fund, transfer it into the individual's pension fund for themselves, or retirement annuity or preservation fund, and then they get to keep that money tax-free, and it will grow for them in the future. So the bias that I have found in my experience is that people think they just want to cash out, they want to write a nice check, pay 5 million Rand into their bank account, and then just go have a holiday and then forget about their 20 years of marriage beforehand. And it's such a difficult thing to try and explain to people that this is a long game. Especially retirement money is money that is earmarked for your retirement for 20, 30 years from today to keep you alive and provide an income for 20, 30, 40 years after your retirement. But yeah, short-term gains, I think, sometimes overrule our common sense in some cases.
Absolutely. As Theresa also said, the 4 buckets become a tsunami. And if you are comparing a pie in the sky when I die, in other words, a pension payout at 60 or 65 or whatever the case may be, versus my spouse is now retaining the lovely house in Midstream Estate, and the long-term asset sort of pales in comparison. So I have one final question for you, Jacques, which I would like some clarity on, and I know will be very, very useful to a lot of our visitors today. And it's one that I didn't ask you to prepare on. So if you say you're bliksem, I didn't prepare on this, that's cool. We can deal with it at a later stage when we go through the question and answer. But we know that upon retirement, a lot of people decide to take a lump sum in cash, and then the rest goes into what's known as, I believe, a living annuity, and you derive a living or an annuity income from that. And one of the huge fights that's obviously going, I'm not sure if you've seen this this judgment in the Supreme Court of Appeal. They let the cat among the pigeons to say that a living annuity can actually be deemed as part of your patrimonial benefits in terms of a divorce. What is your view on that? And actually, more importantly, how does that work? I'm now 65 and I want to take some moolah and live off the Sanlam dole for the rest of my life.
Well, I wish it was that easy. So thank you for your very interesting question, Mervyn. And yes, you are correct. I did not prepare for your specific question, but let's see. At least I think I've had some recent experience in this. So quite simply, there are 2 major types of retirement income generating products for clients after retirement. The one is, you were absolutely correct by calling it an ILA, which is an investment linked living annuity. Effectively, that's an investment on which you earn interest and they draw money, and hopefully draw less money than the interest. Yeah, so that grows. The second one is what they call a guaranteed pension annuity. So that's a bit more of an older type of structure, but it's a once-off structure. You can never ever make a decision after that has happened. So if you have a client that now decides to divorce and their retirement money is sitting in a guaranteed fund, that there's no change that can happen to that whatsoever. That money is guaranteed to go to, contractually guaranteed to go to the party that created the product. And if he were to give his spouse his income after his death, it would go to his spouse, or now ex-spouse, it would go to that person. It can't be stopped. So there has to be some court order forcing the person to pay a maintenance component behind that while he's alive. However, on the other type of product, with the ILA product, which is something that I wasn't quite aware of, but we've recently been able to establish this, that you are absolutely correct. That now falls very similarly into the Pension Funds Act, whereas the trustees of that fund could decide in the event of death where that money goes to, so irrespective of who you nominated to. But not only that, in the event of divorce, there might be a portion accessible to that. So this is still fairly new. We're still trying to figure out exactly what this means. But once again, add some more complexity to it. Thank you to all of our rule makers and lawmakers.
Absolutely. You know, there we really have the SCA to thank in terms of that judgment. And so now I'm sure you're going to jump in with that, because they kind of came in and they said, well, yes, it does form part of your patrimonial benefits of your estate, but they didn't say how, when, how to calculate, how to access, and I'm not aware, and Seugnette, maybe you can just enlighten us if I'm mistaken, that the High Court has dealt with this and given guidance in that regard. But very interesting. I never realized that there's a difference between the ILA and then the guaranteed pension annuity, or
yes.
Okay, and a GPA, I'm assuming. The one being completely ceded the GPA to the fund or whomever, and the ILA actually just being more of an interest-based product. So thank you for that, Jacques. Very interesting. Seugnette, over to you. What do you have to add?
So maybe just to add to that, from a deceased estate scenario, I know we're trying to look around the divorce issues of the day, but for a living annuity, also interestingly enough, which few people realize, is in a deceased estate scenario, we know that all pension and retirement annuity products are excluded from your estate and also excluded from estate duty. And perhaps we can have another session on another day to explain all the differences of what's in and what's out and duties and not. But just remember, pension interests are excluded from estate duty as well. However, a living annuity is different to that, in the sense that it's a can of worms that, or a bucket of money that you literally now opened with your little opener, and it's now open. And because as a living person, you now have access to the funds and you start living off it and enjoying it, you're now on retirement. Just to once the living annuity now assumes you're on retirement and you're now putting your hands into the cookie jar. If you have okay, so you have a living annuity, and the assumption is great, it falls under the Pension Funds Act exclusions and it's not dutiable for estate duty purposes, and it's not in your estate. That's incorrect. A living annuity where you don't have a beneficiary nominated at the event of your passing to go to your spouse or your child or whatever, it will fall into your estate as a full-blown estate asset, because it's considered to be an asset that you had full access to. If you have a beneficiary nominated on it, it will not fall into your estate, and it can then also be deducted in terms of the Pension Fund Act exclusion. So a living annuity is almost treated like a hybrid between the treatments of life insurance, which doesn't fall in your estate but is dutiable, and pension funds, which doesn't fall in your estate and is not dutiable. Where a living annuity, you're on retirement, you're going to live by the coast, and you forget to change your beneficiary, and it comes to bite family. Just the beneficiary nomination can have a huge effect on the taxation and executor's fees and everything. But like I said, that's in a deceased estate scenario, which is different from what Jacques explained.
Mariki, if I can just ask you, please, would you type your question? We're just going to run through the program and then we'll deal with that later, or you can use raise hand function at a later stage. But please do type your question. I'd love to hear it. So now I'm actually going to go over to you because you've actually opened a whole other can of worms now, and it is basically making small emissions that can lead to long-term problems. And I'd like to now move on to your slide based on pre-divorce estate planning. Now, guys, as I said in my intro, please remember this is not bullshitting your spouse 101. This is not what we're talking about. And we're not here to give tips on hiding assets, etc. What we are here to do is to say, look, you have a trust. It is a bona fide trust. Here are the pitfalls that you need to be aware of. So, Sunay, thank you so much for taking the time to come and speak to us. Folks, once again, Sunay is from Wealth Succession. She is also a practicing attorney at Schwim Venter Incorporated, I believe, or attorneys. I always get it wrong. But either way, Sunay is going to chat with us about trusts, wills, joint ownership, and the difference between an accrual and a joint estate. So thank you very much. Sunay, take it away.
Thank you, Mervyn. So, yes, so what we just discussed, Jacques, just flows in so perfectly into where we're going now, in that I'm picking up where I left off with the 4 buckets of assets and how they are each treated differently. And note that in the pre-divorce estate planning, we're treating them separately as 4 buckets. And then when Theresa takes us through the post-divorce estate planning, that's where the tsunami comes in. So bear with me for the time being. I'm still in my 4-bucket mindset. So basically, the biggest issue in a divorce scenario is the fact that clients, and that is what Jacques also said, it's his duty and his role to educate clients for them to understand how different assets are treated differently, are treated with different laws and acts and documents and so forth. But what clients love to really forget, and when you have a first consultation with a client to set up a trust, a family trust, this is the first conversation you have, and they soon forget it. But the principle is, if you have assets in trust, you have to have a mindset of handing over the assets into an entity which is no longer you. It doesn't form part of your estate anymore. You are no longer the owner of it. You're handing over assets into the custody of the trustees who are appointed to take care of it, grow it, protect it, all for the benefit of the beneficiaries. So that's the first point. Years before we're talking about a divorce, when we're setting up a trust, is for clients to understand it's not your money anymore, you're giving it away. And even tax-wise, it's not as easy as just putting it into a trust and magic. It isn't. It is by donations tax. You're giving it away. Or if you don't want to pay donations tax, you're transferring the funds from your assets, your own estate, into the trust on loan account, which means that there's still an accounting entry on which you will still be taxed in your own estate and so forth. So it is physically handing over my house to other people to manage on my family's behalf, whether I'm a beneficiary or not. And this is where clients get confused. And the moment that they get confused, the divorce attorney's brow starts raising, and now they're like, here we go again. So what basically the biggest issue, and there we want to differentiate between a sham trust and an alter ego trust. And it's very important to note that there's a difference. The terms are used interchangeably and very incorrectly. And I just quickly want to set the record straight here. So a sham trust is a trust that actually, well, let's just take one step back to my 4 silos again. The biggest issue that trustees have, and your role as trustee, is to know that there has to be a clear separation of assets between trust assets and the assets of the estate owner or the client. And that's the role of the trustee, to keep that difference separately. And one of the essentials of setting up a valid trust, which we'll get to in a second, is that trust property needs to be defined and accurately determined to be trust property. This highlighter is the trust's highlighter, not the client's highlighter to be borrowed by the trust. Now we're not sure anymore. This is the trust highlighter. So that's an absolute duty of the trustees, to understand that there's a separation and to enforce the separation. And that then speaks to their impartiality. How are they conducting the office that they've been appointed to? And we'll get to that in a second. But just to understand, there's a clear difference between a sham trust and an alter ego trust. Is a sham trust in reality is not a trust at all. A trust was never actually brought to life. it's another arrangement, another contract, another relationship that has been set up to simulate the characteristics of a trust as to confuse third parties or the court or the spouse with regards to what it is. All the while, it's something different. It may be a partnership. It may be whatever else they cook it up to be. And so very often clients have a trust, and then after a thorough trust audit, it can be determined that 20 years ago, a trust really what never was established. It was an order of documentation that was drawn up and handed out to create the impression of a trust. And we have to just give credit to our clients. Very often they don't know this. They're not schooled to know this. They might actually come out and say, I want a trust. And then a practitioner practicing in a type of law where they're not trained to do so sets up a sham, simply because the proof is in the document itself. The essentialia of a valid trust says there has to be an intention to set up a trust, and it comes back to understanding the buckets. I have the intention to hand over assets to people that I'm not. I can be one of the trustees though. I'm handing over assets to be protected and administered for the benefit of beneficiaries. So it's a three-way contract. There's the founder that sets up the trust, that's handing over the assets. There's the protection and management of it by the trustees, and it's all done for the benefit of the beneficiaries. That's the third party in the relationship. And that intention has to be clear. Then there are obligations and being able to differentiate the trust property involved. The object of the trust, what's the object of the trust? To take care of the beneficiaries. Different trusts can have different objects. To simply educate the beneficiaries, get them through education purposes, but not buying, not to set them up for a luxurious lifestyle. Whatever it can be unique, but there has to be a clear identifiable object of the trust. And that object has to be legal. Yeah, I don't think I have to explain that it has to be a legal object. We can't set up a trust for the purpose of going out and murdering people, I mean, so I'm not going to go into that. So there's certain boxes that needs to be ticked, and just the trust deed in itself doesn't say now we've got a trust. We need to make sure that all of these are present. And something so simple is, you may have noted in trust deeds, there's always that line that says the founder now donates an amount of 100 Rand. 100 Rand. I mean, setting up the trust is much more expensive, but we're donating 100 Rand to the trustees to be kept in trust for the purpose of the beneficiaries. From a trust administration point of view, and we'll get into the role of the independent trustee now, proper books of account needs to be shown that 100 Rand was actually paid over, and items like that, and the proper record keeping of trust administration will at the end of the day determine, do we have a trust or not? If it is determined that the trust was never really a trust, that's when we talk about a sham trust. So by way of speak, we love thinking a sham is, whatever, what we're now going to go into is alter ego, but it's not. A sham trust, the wording sham trust indicates that a trust really never got to being, and it's because the documentation simulated something different as, from a trust. And only once you know if you have a trust or not, you can start the conversation of an alter ego. If the trust is a sham, it cannot be an alter ego because we don't have a trust. So an alter ego trust would basically say that the trust is used as an extension of the personality of the estate owner or the creator or the settler or the founder. He's using this trust as a structure to bluff everyone around him, but actually he thinks it's all his own. This is now the client that didn't understand a lesson on day one, that trust assets are no longer your assets. So basically where that comes out of is doing a proper legal trust audit, in terms of which you go through the documentation to say, what does the trust deed say? Red lights that you can see very quickly is trust deeds that says that there's only one trustee. Red, major red light. Why? If you're only one trustee, why don't you just keep it in your own estate and call it my assets? Because that's what you're effectively, doing. Other veto powers. This or that decision can only be made if Seugnette is voting in favor of the decision. I shouldn't have that power in my trust. I should have the power of the majority of trustees to actually stand against me. sole rights to hire and fire trustees, to be able to change trust documentation, to be able to sign off title deeds and banking documents. Those are all the red lights that you will actually find in the trustee documentation. And then as a second test to whether we've got an alter ego trust or not, is the actual facts behind the situation. We can have a perfect trustee that's perfectly drawn up to exclude all of these red lights, but the day-to-day use of the trust is that of an alter ego. The trustee blatantly neglects to involve his co-trustees when the decisions need to be made. He ignores their decisions. He does what he wants to. He pays for his holidays and ice cream and whatever out of the trust bank account. The way that he actually uses the trust day to day and the facts around that indicates that he thinks what's held in trust is actually owned by himself. And why this is so relevant to the discussion we're having today, and with the quote you can see there on the screen that Mervyn just showed us, is in the big case around all of this, and there's been a lot of different case law on it, but the big one we like to go back to is Badenhorst versus Badenhorst, in terms of which they said, well, first of all, the husband now going into a divorce situation was his father was the founder of the trust. He and his brothers were the trustees of the trust. His children were the capital beneficiaries of the trust, and his wife the income beneficiary of the trust. And just note how I'm saying how the trustees are all father, brother, husband. You know, it's sort of a boys' club situation where we all have only one person's interest at heart. And we'll get to that in a second. But in Badenhorst, what happened was the wife said, but wait a second, when it came to the negotiation of the divorce, she said, but wait a second, what about that property and that asset and this and that and the following? And I said, oh, no, it's trust asset. Sorry, it's not included in my estate, so not applicable for our accrual calculation. And the wife said, but wait, all the time that we've been married, you've pretended like that's all ours. That's yours. You know, the boat is yours. We're doing as we please. You don't ask permission for anyone or anything. And you know what? Even when you fill out credit applications in your own name, you include trust property to say this is what I'm worth. This is my net worth. This is my asset value. And back and forth, and a very interesting piece of case law to read. But at the end of the day, the court said, but okay, if you wanted to pretend for all these years that those assets are yours, then congratulations, we now consider them to be yours. And for purposes of your divorce settlement, they fall fully within your own estate. Well done. You've done this to yourself. So learning from what Badenhorst and Badenhorst taught us is that looking into and obviously this happened years later, but what do we need to do to make sure that our clients, this is the pre-divorce situation, are protected? And once again, like Mervyn said, it's not an idea of how to cause damage for your soon-to-be ex-spouse. It's just a way to make sure that you don't cause damage to yourself. Is looking at the trust property and the trust deed and the trust documentation and the administration of it to understand there are certain checks and balances that needs to be in place. And the biggest and easiest one to do is to appoint a proper independent trustee to look after these matters for you. So in 2017, the Master's Office put out a directive to say that for any new trust registrations where it is a family business trust. So a family business trust basically is a trust in terms of which all the trustees are family, all the trustees are beneficiaries, and all of the beneficiaries are related to one another. And the trust has got the capability of contracting with third parties, in other words, creating trust creditors. That's a family business trust. So the Master's Office came in 2017 and said, if from now on, if we're registering new trusts and it's a family business trust, we are insisting thereon that an independent trustee is appointed as a trustee to look out for the things that Badenhorst didn't allow his co-trustee to look out on. So an independent trustee needs to be someone that doesn't have any blood or family, direct or indirect relation to the beneficiaries of the trust. It's someone that doesn't get a benefit from the trust aside from his professional trustee fee. It's someone with enough legal background, accounting background, and business savvy to understand how to actually deal and protect and grow trust assets, but also someone that fully understands the office that they're taking. the risks associated to it, the law that they have to follow, how the Trust Property Control Act works, someone that can read the trust deed and actually understand what it does. So the days are gone where appointing your neighbor to be your independent trustee, for him to be a puppet, it's just not there anymore. You have to have someone professional on board. I just have to include there that this ideally can be an attorney or an accountant or a trust company, but it doesn't have to be. It's not regulated to say it has to be. It can be the neighbor, but you have to understand that your neighbor then has to have these qualities and characteristics to fit the role of office of trustee. Be independent, look at the situation from all sides, be able to tell the family or the founder or settler, no, you're wrong here, or no, we're not allowing that, or sorry, this is not an option for you. So someone that has, can toughen up and make and just set the boundaries. So that's a big major thing in terms of keeping within the divorce scenario, keeping trust assets excluded from the estate. But then, as Theresa will show us, and this is where I absolutely agree with the tsunami, we can keep it separate from the estate for purposes of accrual claims and division of assets. But we need to remember that the surviving spouse, force of habits, that the now ex-spouse is still probably a beneficiary of the trust. So we can sort out if we now just ignore trust assets, and ex-wife is happy to do so, she's not well advised and she's like, whatever, they said it's separate, I'll accept it. And we're able to go through a divorce and it's clear cut and simple. Then after the fact, the trustees in the trust will have their days and litigation days, in terms of which there's now constant conflict in the trust because we have beneficiaries and trustees on the trust that no longer sit on the same side of the table. And that then grows into the same thing that we're talking about in the divorce world of a clean cut. Are we able to separate our lives so cleanly and so meticulously that we know who fits where and who does what? So if you keep the trust separate, which you should, you're going to still have issues because now we're sitting with two estranged spouses across the table from each other trying to make decisions and deal with money and whatever. And Theresa will be able to shed some light on that also later. But what I want to just say to follow up on that is a little interesting tip that we've noted works, just to see if that trust should actually come in as a full-on estate asset, or the asset should be included in the estate calculations, is if you've got a trust and if you've got husband and wife as beneficiaries, and your client, let's say it's the wife, it's now going through divorce proceedings, she should write a letter to her trustees to say, listen, I'm now going through divorce. I'm in the middle of a divorce. My legal fees are stacking up and I'm struggling to keep by. Won't you please just help me with some cash to settle my legal expenses? And then it will come back to the person in the chair of the independent trustee, a person that we've now already established is someone that understands the law, that understands how trusts work, someone that understands that I have to treat my beneficiaries equally. I can't play favoritism. I can't play towards my friend that hired me. And then the trustees have to come back and say, okay, well, no, we're not going to help you, but we're going to pay husband's legal fees or whatever. This is not an issue about maintenance. We're not talking about maintenance at all. We're talking about a trust that was set up to cater to the living expenses or needs of beneficiaries. So write that later and then see what the trustees come back with. If the trustees come back to say, no, sorry, this is just not how it works, this is not what Mr. Smith wants, then the red light's going, but okay, wait a second, is Mr. Smith calling the shots here, or you are trustee calling the shots? And then those conversations have open up, and then maybe just we bring it back into an alter ego scenario. So that's just a sideline thing that we sort of use as a tester to see how legit the situation is. But like I said, the purpose of this discussion is not to screw your spouse, it's just to protect your client. So that's the one.
Absolutely. So now tell me, can any will ever really be divorce proof? Now we've spoken about trust and the pitfalls there, but wills are also a big problem. To give you an idea, I've had, I think, 3 or 4 divorce cases where we're still busy with the divorce and the one spouse passes away. I had a specific one years back where there was an altercation between the major's son and the father, and it was a fatal altercation, and there was a community of property estate, and it was very, very complex. So where do wills really fall into this situation?
I think wills is the number one thing that you think of when you're thinking about death and divorce, and taxes, is that the first thing to remember is that the moment you are divorced, you have a period of 3 months in terms of which you have to change your will. The law affords you 3 months, saying, okay, you're going through a life-changing situation. We're giving you 3 months to catch up on your admin. So you've got your will that says I leave everything to my surviving spouse, or my spouse, or you call your spouse by their name, and you get divorced. And then the law says we give you 3 months to say, if you die from somewhere between date of death and sooner than 3 months, we will not have your ex-spouse inherit. We're giving you that window. But after 3 months, if you didn't change your will, they're saying for some reason or another, you're still friendly with your ex-spouse and you still want to have them inherit because you didn't change your will. And then your old will still becomes fully enforceable. So the first thing to remember is have your will amended as soon as possible. But like you said, Mervyn, this should actually not only happen once we've reached a divorce settlement, a divorce order. Once we know we're getting a divorce, the prudent thing to do would be to change your will at that stage already, because divorce proceedings can drag on for so long. And we see time and time again how we sit with deceased estates that was mid-divorce, and now we still have a will in favor of the spouse that we've already publicly confirmed, well, I'm no longer in love with him, so please don't give my assets to him. So that's a big problem. So the moment you actually had a first consultation for mediators or divorce attorneys should actually be, okay, but let's just quickly look at your will. Where are we at? And then pre-divorce, your options, and that comes into the matrimonial property issues that we have. You're still married until date of divorce with or without the accrual or in community of property. So you can change your will to say, seeing as I'm going to get a divorce soon, I no longer want to leave my estate to my spouse. I want to leave it to my children only. Keep in mind, you're still married in community of property, so your ex-spouse is still up until date of divorce entitled to 50% of everything in your name. If you're married with the accrual, same applies. You can give away your estate because you're married out of community of property. Everything that's in your name that you own is yours, but your spouse at the time, if you pass away before divorce, still has a claim for accrual of 50% or whatever your antenuptial contract stipulated on the growth of the two of your estates during the course of the marriage. So that will still play out. So you'll be able to change your will to say, I bequeath my estate to my neighbor, but just keep in mind your ex-spouse will still receive a accrual calculation. Massing can be a major issue if you don't change that will in time, just before divorce or after divorce. Massing basically means that two people, and keep in mind this is two people, not necessarily always just spouses. It can be two business partners, two friends. Anybody can mass their estates, which effectively means we're putting our estates, we're throwing it all, and the Afrikaans just actually explains it so much better. We talk about boedel same smelting, and that word smelting, really growing, putting the two estates or whatever you're massing, this specific asset together and making it one, so that at the death of the first of us, we are able to transfer it somewhere else, into a trust or to our children or into another business structure, whatever the reason for the massing is. And so if you don't change your will, despite the marriage having been dissolved at divorce, we're no longer married in community of property or out of whatever, but our will still says we're massing. Now we're an ex-spouse. The law still allows massing to occur, even though we're not spouses anymore. And that's a big thing to keep into consideration. So yeah. Oh, sorry. One big thing I just want to mention with regards to changing your will is keep in mind for estate planning that the first thing in estate planning is leave everything to your surviving spouse, because then you pay no estate duty on it. But the moment you're now no longer married, you immediately have a 50% of your estate plan that falls away. So then go and see your fiduciary specialist and say, what now? How are we going to now transfer my wealth to the next generation successfully now that I don't have the option of having a tax break because I left everything to a surviving spouse? I no longer have a spouse. Jacques, what's up?
Sure. Jacques, over to you.
Wow. So just adding on to the complexity there, Seugnette, is you need to remember also in terms of beneficiaries or nominees on policies. So not only changing the will, but changing the beneficiaries and the timing of changing those beneficiaries, what fun that creates in the event of a death. So I just wanted to add that to you.
Absolutely. The admin that the clients needs to take care of, and a lot of it can be done while in divorce negotiations and while working towards that divorce order. Something else that really creeps up, and I'm doing an estate currently where, without giving away too much information, but the clients got divorced 10 or 15 or 20 years ago, and now that the estate fell open, we realized that they still have joint survivorship accounts offshore. So that's something South Africans are not too familiar with, but for clients with offshore assets, many offshore jurisdictions, for example, UK and even America, whatever, has a component where two spouses are joint owners of a bank account, and on the death of either of them, the whole account immediately vests in the life of in the estate of the survivor of them without it going through an estate. So it just happens automatically. And that's a great estate planning tool if you're married, but once you get divorced and you forget to go back to the UK to change that bank account, 20 years down the line, ex-wife still gets that account because you still got joint survivorship bank accounts. So the worms just keep on climbing out. So the best thing that you can do for your clients is during divorce negotiations and conversations, and just after getting the divorce order, is to have a proper quality conversation with your estate planner, with your financial planner, with your fiduciary specialist, whatever it is that they call themselves, the person that knows where to look for these bugs, because there's a lot of admin to be done. And like we said earlier, they would like to pay out the pension fund and go to the coast and say, oh, I'm just taking a break out of just what happened to me. Sorry, do that after you've done all your admin, please. Go there after your admin is up to date.
Absolutely. I must be honest, I've done very few divorces where we walk out of court and the client doesn't immediately reach for the bottle of champagne or the whiskey or whatever the case may be. And I suppose it's such a huge catharsis and such a huge relief for people that they forget about these things. So to our attendees, I want to throw something out there, and I didn't warn any of my panel members. In fact, I didn't think about this before now, but there are so many things that need to happen after divorce. I'm wondering if there would be sufficient interest in having a short document prepared, a little checklist for mediators, attorneys, etc. So please indicate if you would be keen on getting something like that. And if we have sufficient interest, I'm sure I can twist Seugnette and Jacques and Theresa's arm to work with me to make some sort of document like that, which we can obviously just distribute between our attendees and all of those on my mailing list. And what's interesting, I must be honest, and also, guys, please use the comment box and indicate whether you agree with me. But from my perspective, even as an attorney who is considered to be fairly legally savvy, a lot of what Seugnette has said so far and what Jacques has said so far, and we haven't even gotten to Theresa, which is going to be even further perspectives on it from a mediator's point of view. This stuff can get overwhelming. Guys, panel members, I'm sorry, we've got work cut out. This comment box is like lighting up big time. So sure, what have I gotten us into here? But this is such a broad field of study. We were actually talking before this webinar started how long one can actually just talk about this. This is to go through estate planning as a whole is just so broad. It is simply impossible to do it in the context of a webinar. But as the saying goes, know everything about something and something about everything. So on that note, I also want to really encourage you guys. to reach out to some of these professionals. I know a lot of us today in the session are mediators and or divorce attorneys or mental health practitioners that work with divorce. We may have an interest in things like estate planning, but we're not estate planners. So please do take the time to reach out to people like Jacques, like Seugnette, who really do this stuff for a living. And I'm sure if any of you want one of our particular panel members to get in touch with you directly after this, please do reach out to them. Use the chat box. It's there for a reason. And I promise you, I made them promise me that they will get in touch with you and grab a cup of coffee and discuss. So, sure, Seugnette, that was awesome. Thank you so much. I'd like to pulse you on one or two things just before we go over to Theresa on the mediation and the post-divorce estate planning. You know, issues such as joint ownership of assets and joint estates, you know, that's obviously quite a complex issue in terms of one's estate planning. Is this something you see frequently? You know, people who want to create a trust or want to create this vehicle, yet they're married in community of property. And what are the problems that you often see in terms of your community of property estate planning?
I think and perhaps Theresa will expand on this when she assists us a little bit of the negotiation and bringing all the buckets into the tsunami. But I think one of the biggest things to take into consideration is in a trust, there's not really an option where you can, when you divorce or when the communal estate no longer is, or there's a change of matrimonial property system, which is also possible. We cannot say, okay, let's split the trust funds. You take 50, I take 50, we part our ways. It doesn't work like that, because if you understand the structure of a trust correctly, you understand that you don't own any vested portion in it. Not a percentage, not 1% of it. You only have the hopes of possibly someday having a benefit conferred upon you. So you can't, in your negotiations, say let's take a knife and cut it into certain sections. You have to have an open conversation to understand who. And it's troublesome waters to tread, because if you're not going to start to say who contributed what, who added what, and how did that grow, then we're once again playing around with alter egos and so forth. But between spouses, irrespective of understanding the separation of trust property and estate property, communal asset property in a household, there's surely an understanding of whose money, you know, was paid into trust and grew the trust fund or whatever. And those factors come into the emotional, factual side of the negotiations. But when you look at the separation of that, the best thing that you actually can do to try to separate trust assets, now that you are trying to sorry, I just want to see, I did make a little note about it. Now that you're trying to separate trust property, is to say, if we wanted to have one of the trustees and or beneficiaries, let's say the wife, now be removed from the trust because we're no longer married. Very, very careful to do that, because you can't just say because we're not married, because you're a beneficiary of a trust. You're not a spouse. In that chair you're sitting, you're a beneficiary equal to your children and whoever else is beneficiaries. But what you can do as part of the negotiation is say, okay, me as the soon-to-be ex-wife want to step out of the trust. I don't want to be a beneficiary anymore. I'm willing to renounce my rights as beneficiary of the trust. But there's going to be a price to it, because is there any way, a way that I can put rands and cents to worth my worth as a beneficiary? And legally you can't, because it's just an expectation, not a right. But you can say, okay, the trust is worth 20 million. If you want me to step out, possibly a distribution to the amount of 5 million or whatever will make me feel comfortable. So there the negotiation comes in. And if you want to do that, then it's important. And here I'm going into waters that I'm not trained on, and that I'll throw over to you, Mervyn. But then when you get into the divorce negotiations, you have to understand at what time you have to join the trustees and beneficiaries of the trust as a party to the divorce.
Oh.
So if you're bringing that in, there's a litigation aspect to it as well, where if we're going to renounce rights as beneficiaries of the trust because we want to now bring it all together, we have to understand the legal process of citing the correct parties and joining the correct parties into the divorce litigation, which I unfortunately can't expand on too much because that's not my field, but I understand that to be something someone should look at.
Absolutely. And, everything is negotiable. And on that term of everything is negotiable, I'd like to hand over the floor to our next panel member, Theresa Luyt. Theresa is the owner of Mediation Network. She is a practicing mediator and an incredibly active mediator. Theresa is also a non-practicing certified financial planner, and I asked Theresa specifically to join us today to talk to us about mediation in divorce and post-divorce estate planning in the mediation context, because as Seugnette showed us, and as Jacques showed us, we have these little buckets. But unfortunately, when you get into that negotiation table, the buckets fill with tears. And then all the buckets become one, and you're sitting with a cross-pollination of tsunami between buckets. And how to deal with that in a practical sense in terms of divorce is incredibly important. So over to you, Theresa, if you will talk to us about post-divorce estate planning and give us a few practical examples. After we've gone through Theresa's slot, folks, we are going to take a 15-minute break just to refill our cups of coffee. Then the fun is going to start. We're coming back for the Q&A session, and you can try your utmost to stump my panel members, but not myself, because I'm going to just hand over to them. So please start thinking about your questions. Don't be shy. Put them in the comment box or write them down, and you can put up your hand a little bit later. We're going to recap some of the main issues touched on as well. So without further ado, Theresa, tell us about the sports in the mediation room.
Hi, Mervyn. Thank you very much for that introduction. First and foremost, I want to explain why Mediation Network happens, because it's applicable to today. And I want to reiterate that to mediators. Mediation Network, I might have been the founding member, to quote the trust sort of lingo. I might have been the founding member, but we're a community. I come from a very diverse background, and it has given me a little bit of insight in a lot of the industries that the previous speakers were talking about. And as a mediator, it alerted me to the fact that we need each other. So I want to speak about estate planning in the sense of how does it fit in with you as a mediator? The first thing I want to say is a mediator is never the judge, the magistrate, or the jury. You need to understand that first and foremost. It is not your place to actually advise the clients. That is the parties to the table's attorney's position. It's like a little play, and we all have our role to play. There are professionals that can advise people on aspects that's a lot more knowledgeable than you are. You are the facilitator that starts the conversation, that controls the emotion in the room, that controls the narrative. Where the decisions are going to be made, it's not your job. It is not your duty to point. I say in my mediation often, when parents, for instance, walk into the room, I can put the legal position on the table. I can bring you an attorney's opinion. I can give you a financial advisor's opinion. But unless you decide to sell your children on the black market, I have no say. So I only intervene, and my job starts only there when people decide to do something illegal. It's pretty much the same as with a trust. Okay. So in that regard, I want to say, when it comes to handling your mediation, educate yourself by contacting all of these specialists, because you do not need to be a specialist. You need to be trained to see the red lights. It's the quintessential, you can hear the bell, you don't need to know where it's from. So, because then you know which specialist you're going to need to have a conversation with in terms of to help you with a specific problem. So I use little tricks in my mediation in that regard, and I'm going to talk about that in terms of, it's going to feel a little bit up and down between the trust and the wills and whatever, but I use little things like Mervyn was saying to point people in a direction where they are understanding that there is post-divorce a need for certain help. Once again, I can open their eyes, I can try and facilitate the conversation in that direction, but I can't force people to do anything. So the first thing I do in my parenting plans and whatever is I open up the conversation to two parents sitting in front of me, and I ask, what is going to happen to your children when both of you die? So that is a very obvious question, and I bring that into the mediation, into my parenting plan with a purpose. I say to them, look, if we cannot agree on this, okay, then I suggest we maybe go see someone that can assist us with drawing up a will. Maybe we should have another session to discuss this, because that is something that brings a lot of attention to specifically the fact that we have done the will. I have also a specific portion to my parenting plan, sort of on my checklist, where I say, have you updated your beneficiaries on your policies? Have you actually done a new will? On just normal everyday people that doesn't own a lot of assets, and that doesn't really need all of these like different buckets because they're a salary earner and they don't have a lot of specific assets or investments or anything like that. I actually offer them a free will as part of my parenting plan advertising. And in doing that, I am utilizing a financial advisor that I have a relationship with, and well, a couple of them, because as mediators, we can't recommend one person. We need to put at least 3 options on the table. So this is what I do. I say, listen, you need it. Each parent gets a free will. There is your choice of 3 or 4 financial advisors that are willing to do a will, a very simple will for you for free. As a mediator in the boardroom, you will also know who these high-end individuals are. When you are dealing with these high-end individuals, make sure that you actually suggest someone like Seugnette, whatever, that can help them. If there is an estate already in place, when it's post-divorce and whatever, that they can actually continue planning this. I must say to you, as a technique in the boardroom with divorce, if you bring these things to light for people and you start showing them that there's light post-divorce, this is how we're going to sort this out. This is the person that's going to help you with that. The energy in the room lifts, and you come a lot of the times to much quicker to a conclusion in your mediation. It brings me to something else as well that I want to talk about in terms of trusts. Trusts is always in divorce contentious. I don't care if the 2 of them agreed and went to go see the lawyer and everything about the trust was absolutely perfect about 5 years ago. When the pawpaw hit, everybody is accusing everybody else of misuse, mismanagement, blah, blah. This one will run to his attorney, this one will run to theirs. My suggestion is always, can I give you 3 names on the table? Together, we decide on one person. We don't have to use their advice afterwards. Listen, the decision will only be made at the end of mediation. But let's bring in, we decide which one, the specialist that will interpret the trust documents for us, that will give us proper advice. We can use it or lose it, whatever. That's part of the mediation. We will negotiate on basis of that. So in terms of trust, that's one of the things that I do is, and don't give them the option of 20 as a mediator, just like give them 3, okay? And also give them the option to bring their own suggestions. This is what mediation is. It's negotiation. It's about being fair. It's giving everybody a chance. In terms of trusts, there's also a couple of things that I've done as an example, and I will give you some more information in that regard, and little tricks that I've used that comes from my training as a financial advisor, and also the very little estate training I had many years ago when I was doing my articles. So, but it's things that I use in the boardroom that is very, very useful. In a trust, I've had a really high-end couple that just had, there were 2 or 3, one offshore, 2 offshore, one in the country, investments in that regard, that they couldn't agree on how it should be split. I'm not going to bore you with the details. There was a lot around that. But what we suggested to them as one of the options, remember, mediator creates options, is creative, gives suggestions to break deadlock. As I said, then if you both are saying to me inside caucuses that that money was earmarked for the children, so why don't we actually create a trust for these assets and we don't actually split it up between us? We just agree that this should not be split, this should go to our children. So that was quite useful, okay, in that regard. So I want to, on that note, I want to come back to a couple of the examples of, you know, give mediators and attorneys that's part of this conversation of ours, a couple of ideas in terms of what I've done to break deadlock by understanding estate tools and financial planning vehicles and tools and policies and whatever on that side as well. One of the ones is that I had a father, and this is one that I saw a mediator see often, that absolutely refused to pay cash into the other spouse's account for the children's maintenance. This person had a lot of opinions that she's using the money for her hair and her nails or not, it's not going for his children. So what we did in that regard is I said, right, he's willing to pay the tangible costs. And then we sort of like took that savings contribution, because they were both contributing to sort of like some savings individual for the children post 18 for maybe tertiary or whatever. So I said, okay, so if mommy, for instance, forfeits, please, I've seen both sides, so I'm using mommy and daddy in this explanation. But if mommy forfeits her contribution, she doesn't have to pay the contribution towards the policy. Then we actually go take out a proper education policy with a financial advisor. We don't have this, oh, we're both saving, because in mediation, especially in divorce, people don't trust each other. So that's where something like a policy document that cannot be forged, that cannot be faked or anything of the sort comes to mind, right? So dad is now paying mom and dad's portion of the education policy into that, and he's not paying cash for the day-to-day maintenance. So this is an idea in terms of sort of like more creative thinking and whatever. Then there was another one very closely related to that. The parents had unit trust when they were still together, and they utilized this saving, and they used to like invest into this monthly so that they can utilize that annual beginning of the year. Private school gives you a discounted rate if you pay in a lump sum. So they used it. So post-divorce, they cashed out the unit trust and everybody just went their own way. So what we did is we brought a financial advisor to the table. One of them had a suggestion that they both enjoyed, so they used their own financial advisor. We pulled the money together again, and for the first year it was a little bit tight because they had to put away some money into this unit trust and also pay the school fees. But by January they could utilize this unit trust to pay the kids' bulk school fees for the next year. So all of a sudden the increase in school fees, that was a mediation that lasted about 3 hours just on how are we going to manage the school fees. And trust me when I say to you, even where do you stay and where do I stay and how unfair it is was also pulled into the conversation. We solved this by pooling a unit trust again. Okay, so and there's other examples of that as well that covered the school fees. Okay, then the other thing that's very valuable, when you have relationships with financial advisors, estate planners, and especially also auditors, okay, these are people that can do business valuations. Now, one of the things that I see often, I think it's something written on my forehead or maybe my background, but I see a lot of small business owners. So mom and dad had a little mom and pop shop, and now they're getting divorced. So the problem with that sort of situation is that those businesses are normally not big enough to already be in a position where they have key man policies and contingency plans and all sorts of things in place. So what do you do with those people? They can't just close up the business, sell everything. It sounds very easy. You know, sell it off, cut it off in the middle, and we all both go our own way. Both of these people are very much dependent on the income from this business. So, you know, the only other option in that regard would be for, you know, we have to, for all eternity, continue to work together and try and negotiate a negotiation process, right? You know, contingency sort of relationship. Those doesn't often work. It's a very specific couple that can do that. But what if we can utilize a financial advisor and we can say, for instance, okay, so bring into this for us some key man sort of structures. Why don't we use a bond originator and see if we can't get a loan for the one person to buy the other out? Why can't we use some of these very interesting mechanisms? When you have a case like that, please draw up your NDA, right? Get in your little car and go see an expert, okay? Because they will generate ideas like this for you in that regard. Pet owners, don't get me started. I often joke, one of the second or third parenting plans right in the beginning that I had to do was a parenting plan for a Shih Tzu. And we were so worried that we're going to have to endorse this with the family advocate because I just don't want to see his face when I hand in this parenting plan. So in the future, what I've started to do with pet owners, for instance, just off the topic, this is not so much estate planning, but it gives you the scope. The one pet parent was paying for the insurance and the other one was paying for the obedience school. So I want to say to you, when it comes to kids and the estate planning post-divorce, okay, also think about it that way. One of the ways that you can get the parents to actually understand that they are on the same page is to give them one common goal. And trust me, as the famous song Sting says, the Russians love their children too. It doesn't matter how much the other parent hates you. They definitely love their kids too. So it's one of the big tools from a financial, that's the one thing. And from a love of their children point of view, point them in the direction of these people because it will actually bring a lot of sort of like alleviate a lot of the pressure on the mediation for you. I just want to see if there's in that regard not much further that I don't know. Oh, there's one other example. During COVID, I had a case where a father lost his job. And he actually, if I didn't point him towards the financial advisor, he wouldn't have remembered that he actually has a policy that covers that, that's got that income protector. And I sent them both. They were fighting like it's crazy because it was on the one side, well, on both sides, they were in agreement there was a lack of money. Mommy was looking for a maintenance and dad couldn't pay it. So we sent them off to the financial advisors. And let me tell you, some of these people are so skilled. You know, it was made some policies cashed up, got some policy holidays on some things and whatever. It was amazing what these people could do for them. And at the end, they were fine until dad could find a new job. That resolves conflict. That rebuilds trust between co-parents. This is useful tools for a mediator. Remember, we don't end relationships. We create restructured families and we give people an opportunity on a better basis to move forward. These people normally think that experts like financial advisors and estate planners are outside of their reach. Bring that back into their sphere because there's a lot that we can actually do in that regard. Okay. Then I also quickly want to talk about, we were talking about trust wills, we're talking about estate planning tools and how we can assist in divorce planning. Then also pitfalls in terms of for mediators. Please be mindful when there's pension funds. If you are not trained to do a settlement agreement, make use of professionals that are. There's a lot of mediators that are really, really good mediators and brilliant at negotiating, but they don't have those skills to do the drafting. sit and work with someone. Pension funds, notoriously, judges get very, very itchy about them as well, judges, magistrates, whatever, in divorces, because pension fund administrators, and that's part of my background again as CFP, because I come from pension funds, is that the wording has to be absolutely perfect in that settlement agreement. I have one right now that has not paid out, even though the settlement agreement was drafted, it hasn't been paid out for about 7 years, simply because the wording was done wrong. So we are still fighting that. Now it's attorneys and additional legal fees and trying to sort that out. So please, pension funds, please, big red lights. Have a conversation with someone when you see a pension fund. It's easy normally in mediation, I must be honest. They normally come to you straight away. The pension fund is not very often part of the fight. A lot of the times it is, you take yours, I take mine, off we go. Or, listen, I don't want his pension fund, but I want the house. So, you know, you have to understand when to actually pull in professionals. Shortfalls on anything that you are dealing with. Okay, so we also talk about shortfalls in your estate planning, in mediation, and in your negotiations there. It doesn't very often come up that there are certain shortfalls. One of the things I do is, once again, my little checklist. Have you updated your beneficiaries? Have you updated your will? Have you whatever? Is one of those things, like, please go see a financial advisor. Addressing shortfalls is not a mediator's duty. It is not even a normal attorney's duty. And I see a lot of attorneys advising their clients, don't worry about it, we'll talk about it later. Those things are really important. Failure to plan as well. From an emotional point of view, when we negotiate in mediation, there's a lot of these, like, failure to plan that comes to light. I often see divorce as a spotlight, actually, not an end, because many times it is the spotlight on your life to show you that you weren't planning for this, you weren't planning for that, you weren't planning for your children. You know, especially younger couples think they have a lot of time to save for a retirement, to actually make provision. Oh, I don't need a life policy because, you know, I'm young, I'm not going to die next week. So anywhere between divorce and COVID, that whole idea went out the door. So mediators, please stress this, because the moment you get your clients to actually start a plan, the emotion reduce, and then you have more success in the boardroom. Then from that point of view, I also want to address some of the other professionals on this panel, not only, but also in our audience. And I'm talking specifically to the financial advisors, the estate planners, the attorneys, people like that, that's online here. A really good mediator, that you have a relationship. This is me selling our mediators, okay, is a really useful tool. I have often said, I've gone into a situation where 2 attorneys approach me and they say, you know, that they need to make a decision on a business thing, right? Something, the case is right there. But I go in and I do a restorative process with 2 people, okay, just to fix some fight that happened between the brother and the sister in 1952, right? So just there, just me not getting involved with the technicalities of what this is, I can actually go in and I can fix that and give them an opportunity to negotiate successfully. On estate planning and with wills and that sort of thing, family mediators can also very much assist, for instance, where there is beneficiaries to a will that has passed away, and you know the will cannot be finalized because the brothers, and he died intestate, and the brothers and the sisters and whatever just cannot agree about how the assets should be split. So we have many examples of that. You know, all of my panel can agree that we know that. Okay, so at the end of the day, there's benefits to that. I want to say to people as well, make sure, please, it is not a mediation if there is not a contract to mediate. Mediation is not peacemaking. There's a place in this world for those people too. Mediation is a structured process that has a lot of informal element to it that gives us an opportunity to start a conversation. So other professionals and attorneys, firstly, if there isn't a contract to mediate, it's not a mediation. Secondly, please, unbiased. These people are unbiased. Make sure that you remain unbiased. I want to say to mediators and to professionals, please pick a lane. If we work together and we're really good, everybody at what we do, we can offer such a superior service to these clients. Attorneys, be mindful of clients understanding that you've got mediation training and asking you to negotiate on their behalf and try and negotiate. Build relationships with mediators so that you can wear the attorney hat or the mediator's hat. Okay, pick one. Because when it comes to confusing those roles, to get back to Sinead's buckets, I love that, Sinead, I'm going to steal it, okay? When it comes to the roles we play in a divorce as professionals, there's also buckets, there's hats, pick one, because we can only do our jobs when we're actually doing this correctly. Other than that, yes, I'd also just want to say, if anybody out there wants to make contact with us at Mediation Network or all the other panelists, please make contact with us. In our industry, and every one of us deal with families, and it's not always about just referring business and making money. It's sometimes also just about supporting each other and having a conversation about difficult cases that you are dealing with, and actually just supporting each other. So yes, that's it.
Thanks, Theresa. So it really is such an important thing, and I appreciate you highlighting different people doing their different tasks. And I think it's something that is often overlooked, is that just because there was a family unit and it's now split in two doesn't mean that there has to be an incoherent financial plan for the future. And it's actually such a huge opportunity, the whole idea of mediation, for parents to sit and say, look, we've got our own differences, but how are we actually collaboratively going to structure our financial affairs so that there is enough money for university, there is enough money should one of us pass away, etc., etc. So thank you so much for that, Theresa, bringing everything from the conceptual and academic point of view to really practical examples in the mediation room and the boardroom. So guys, what we're going to do now, it's now 11:15. We've made fairly good time. For those of you who are still around, we only had 5 people drop off, where I think the attention span might have suffered a little bit. Thank you so much. I know it's been a long hour and a half, hour and 3/4 to get here. So I think all of our attention spans may be a little bit shot. So my suggestion is, let's take a breather until 11:30. Then we're going to go into our Q&A. Shantae has been taking notes of the questions that have been raised, and I would love to really engage with everyone and hear about their thoughts. You know, we're all here to learn from one another, and then we'll go into a Q&A session for as long as it needs to take. I have scheduled this until 12:30. If we finish before, then great. If we finish after, then no problem at all. Just before we go into the break, for those who are interested, it's not on a slide specifically, mediators, mental health practitioners, anyone dealing with families, we do have a WhatsApp group which I've started a while back, where you can ask one of our attorneys questions on the fly. If you would like to be added to that WhatsApp group, please do get in touch with me and I will add you to the WhatsApp group, where we can answer some of your questions. I might even be able to twist Sune's arm to come in from an estate planning point of view. Skimp. Then after the break, I'll also, if my panel members are comfortable with it, I'm going to also just distribute their contact details. I see a couple of people having reached out, wanting to make contact with some of our speakers today. So watch this space. That will be coming after the break. It is now 11:20, and I will see everyone back here at 12:30 for discussion and question and answer. If you've got further questions and you're not comfortable raising your hand and talking to us, please pop the questions into the comment box now and we'll have a look at them. We are going to just recap one or two things tonight. In preparation, I'm going to ask you to recap the 4 silos. Someone asked us to just recap that. If you can just talk to us a little bit more about what goes into each silo. And then Jacques, if you can please just recap after that the annuities in divorce, just how the retirement annuities and living annuities work. For Mariki was one of the first recap requests that we got. Great. So I'll see you guys at past after the break. Go refill your cups of coffee and we will see you shortly. All right, welcome back, everybody. I hope everyone had a lovely break and a good coffee refill. I see lots of people running back to their cameras. Thank you so much for sticking around until this portion of the meeting, being the question and answer session. I'm going to ask Seugnette to recap the buckets first, then Jacques, if you can just recap annuities and divorce. Guys, I hope for my panel members, I hope you don't mind. I have put up their contact details on the screen. So please do reach out to these people. They are consummate professionals. I have dealt with each of them personally, and I really, really do have no reservations in recommending them to you. All I do ask is these are their personal contact details. Please do use it judiciously and please do not spam my panel members. They might give me a smack, especially Theresa being a Vrystaat girl. I'm a bit careful there. Thank goodness this is via Teams and not in person. Otherwise, I would have to kuss right now. Right. So I think on that note, Seugnette, if I can ask you to recap for us just the buckets, that whole model, and some examples on a practical level of things that would fall into each bucket, if you don't mind.
Perfect. So there's the 4 asset silos, and I did share a link in the notes where you can also just go and look up it on our website. But basically, all types of assets and liabilities fall into one of these 4, somewhere or another. So the first is the trust silo. We discussed that extensively, and that is regulated by the trust deed and the letter of authority and managed by the trustees of the trust, not the beneficiaries, not the heirs, or whatever other words can be used. Trustees of the trust manage those funds, and that can be a whole portfolio on its own, physical property, investment property, whatever. Just one limitation in the trust silo is that South African trusts cannot own offshore investments, offshore property. So there is something that just a heads up. And then also further to on all 4 silos, which we'll expand on now, they are also replicated globally. So you'll have 4 silos locally for your South African estate is the wrong word because that's only one of the 4 silos, but your South African wealth and then an offshore wealth. And then how these interact with each other is also quite exciting. For example, if you've got heirs that live in Australia, it would be highly unbeneficial for them to receive any benefit from a South African trust tax-wise. So if you understand how the buckets work, you know that you would rather maybe for your Australian child leave everything in your estate and then earmark everything in trust for your South African children and so forth. So once you understand the jurisdictional limitations and possibilities of the 4 silos, you are able to do your estate planning to accommodate different jurisdictions. But okay, so number 1 is the trust silo. Number 2 is the estate silo. So that is physically what we talk about when we say this is your assets and liabilities. It's something where on the letterhead it's addressed to you. And that is also where your will comes into play. When you read a will, it's only dealt with whatever is in silo 2, which is your assets, your house, your car, your investments, and so forth. Then on the 3rd silo is companies and closed corporations. And it is important to note that the shareholding of companies or closed corporations is held either in silo 2, your estate, or silo 1, your trust. but it isn't a silo of its own because it's also governed by the Companies Act, Memorandum of Incorporation, shareholders agreements. There's insurance that plays into it with regards to buy and sell agreements and so forth. So we keep it separately because we have to give recognition to the fact that it's a whole animal in its own, and that it only plugs into either asset 1 or 2 when you have a full understanding of the capabilities within silo number 3. And then silo number 4 is pension and life. So that would be life insurance policies. Obviously, life insurance policies with a beneficiary nominated will not pay out into your estate, but we do have a little arrow going back to silo 2 because we have to remember we're going to pay estate duty on it. If you do not have a nominated beneficiary on your life insurance policies, it will go directly into your silo 2 and it will form part of what will be dealt with in terms of your will. Pension assets can then be further split down, and Jacques will take us a little bit through some of those. Pension funds, provident funds, retirement annuities, living annuities, and so forth. And yeah, like you all know, that also is a beast in its own, dealt with by the Pension Funds Act and the rules of the specific product and the rules of the trustees of the fund, respectively. So that's that.
Wonderful. Thank you, Seugnette. Then, Jacques, I'm just going to ask you to quickly recap just on annuities, retirement annuities and living annuities. And then thereafter, there was a question on annuities on divorce. How does that work? And we can address that if you're comfortable. Otherwise, I'll address that issue, and then we can go into the formal question and answer and address some of the comments in the comment box. So over to you, Jacques.
I'm starting to run out of paper with all of the notes I'm making. Thank you very much, Seugnette. I don't know how I'm going to get all of this in my head, but let's try this. Right. Very technical scenarios in terms of what we're talking about: pension fund, annuities, provident fund, those types of elements. Exactly what Seugnette said before is that there is definitely a component of pre and post-retirement that we need to look at. So the pre-retirement one is probably a simpler answer in terms of this because it's generally controlled by the Pension Funds Act initially. And they, just as a bit of advice to anybody dealing with mediation from that side, Mervyn, and I'm sure you'll have experience with this, is if you are not super specific about what the exact value is that you're sharing, I mean, it has to be calculatable to the infinitesimal component of a cent to be able to be enacted. You have to be sure that you are delivering the documentation to the pension fund administrator, not his or her company's head office or branch office, because that means absolutely nothing. It has to be so specific that it is unequivocal, undoubtable. This is Mervyn's pension fund that we're taking, and we're taking 100,000 out of this in order to settle pension fund debt to go to XYZ party. So it's very key to have those pre-retirement components in case of divorce sorted out and have them super specific to be able to enact them. But once we go into a divorce scenario after retirement, it does change a little bit. And just as a reminder, we were talking about now, we have to start looking about what specific products the client has taken up to provide his or her retirement income. So generally at time of retirement, there's usually a cash component that could be taken out by the individual, but generally the bulk of the capital that is put together is there to provide an income for the rest of their natural life. So at the time of doing that planning, a financial planner like myself will sit down with a client and we'll decide, right, hubby and wife together, this is the income that you're currently earning, this is how much capital we have, this is how much income we can provide going forward. And then based on the product that you use, it will change the rules. So as I stated earlier, one that you'll hear a lot of, and this is more of a modern day product, is something called an ILA, or an investment linked living annuity, which effectively is a savings plan where you invest the money, earn interest on it, and then you draw an income out of that with the hope that you are drawing less money than you're earning interest, ultimately to protect your capital. The second component then is something that's a bit more of an old-fashioned type of product, but it does definitely have a space within every market, which is a guaranteed annuity. Now, guaranteed annuity very simply provides for a guaranteed amount of income or guaranteed set of rules income that will grow at a very specific and guaranteed amount for the rest of the individual's life, or for the rest of the individual plus his spouse's life or partner's life, or even then ultimately guaranteed to provide an amount of capital back to them. So you're looking at single life, joint life, and capital preservation funds, annuities. And those will have completely different rules when it comes to divorce after retirement, because those guaranteed contracts are set in stone and you cannot change those contracts. It's one bite of the cherry, and that bite of the cherry only happens at retirement. You can't change it. It has a specific set of rules, i.e., for the rest of my life, I will receive an income. It will pass to my wife until she passes away, or in the event of me passing away, she will get a capital amount back. Those nominees or beneficiaries of those policies can't be changed. It is fixed. So if people divorce after that happened, it's something that you need to take into account as a mediator in terms of these options. So I would highly suggest, and this gets super, super technical with this, is get in touch with somebody like myself so that we can try and help and guide you in terms of what the product options are. And these are product options that we can't change. When it gets to the ILAs or the ILI type of products, which is the investment-linked living annuities, there's a nominee that can be changed. But the nominee changing it would only be enacted then in terms of death. So in terms of death, the nominee would then inherit the money. But now, once again, you could fall back to the Pension Funds Act on that, and the trustees could actually make the money or the nomination be revoked and be shifted to people where they are more dependent on the income. So if you have an ex-spouse, you have a new spouse, life becomes complicated, and I highly suggest that you have a chat with us so that we can just try and work out what the complexities are of the product specifically and the legal side of this.
Awesome. Thank you, Jacques. Guys, I want to clarify one thing from what Jacques said, and I saw there was a hand up on a question, so I want to do this quick clarification and then go into questions on this. Mariki, I think you had your hand up. Guys, understand that in South Africa, we have what's known as a clean break principle. So it used to be in the olden days, if there was an assignment of a pension fund or a pension interest is the accepted term in the legislation, that you would only become entitled to it as a non-member spouse on the date when your spouse or the member spouse would become entitled to it. And obviously that's a hell of a big problem. Then you wait 20, 30, 40 years. So now what the position is understand that these are deemed to be an asset in your estate or in the joint estate as at date of decree of divorce. So on the date of divorce, there can be an allocation paid out either to the non-member spouse in cash, or it can be transferred to a qualifying fund or an approved fund in terms of legislation and or the rules of the particular fund. So Jacques, just to clarify from what you said earlier also, so that everyone understands, when we spoke earlier about the tax implications, that relates to, let's say mom has the pension fund and dad gets an allocation. Financially, dad is much better off reinvesting that into an approved fund rather than taking cash, because then Caesar is going to say, give me what I'm due, and obviously then some. Mariki, I don't know if this answered your question or whether you have a follow-up question from there. You can just hold thumbs up if you're all good.
No, I just wanted to know, so once you've actually settled that contract, saying, okay, this is the one I nominate, she will receive money for the rest of her life, there's no way you can change it. Is that what you want to say, Jacques?
So Mariki, that depends on the type of contract.
Yeah, that second one you spoke about.
So on the ILA specifically, there is an option to change.
Guaranteed one, yes.
On the guaranteed one, no option to change it.
Oh, wow.
Thank you so much, Jacques. And my understanding of it, the guaranteed one is that is the situation also where you actually seed the investment to the insurer and they then guarantee you. And that's why you can't change it, because you are going to be the one receiving the annuity income by means of contract.
Correct. It's
you don't have capital asset.
You've given up your right to the capital amount and you've exchanged that for a guaranteed income. And that's contractually the only thing that you will receive from that for the rest of your life.
Excellent. Theresa, you want to add something, and then I want to actually pose a question to you as well. So keep it quick. I've got an interesting one.
Ricky, just to clarify for you how you should think about that guaranteed product. It is almost seen by the company like a life policy to a certain degree. So they assess you as a person. Yes, they're going to take your money, but they assess you as a person. So the specific beneficiary is part of the evaluation process. And that is why that cannot be changed. Okay? So when you start looking at it from that point of view, that the company, the insurance company sees those two, the money and the person, absolutely linked in terms of whether they're going to give it to you or not. That is one type of product. When you're talking about a normal annuity, it means you've got a cash amount and there's an interest that's going to be paid out to you monthly. It's not linked to anybody that you can change. So if you understand the thinking of the insurance company, then you understand what the difference between the two is.
Absolutely. Thanks for that, Theresa. On a very practical point there. Mariki, you want to clarify one more thing, and then I'm going to go on to the next question. You're welcome.
Does anybody understand the insurance companies?
Brokers and financial advisors. That's why you need them when mediating divorces. I think that's really the crux. Is this shit is complicated.
And to be honest, sometimes even I have to go ask the question, so that's fine.
The thing is, guys, that this stuff is so broad, even in the industry, and the industry moves so fast that you get product specialists. Jacques, I'm sure you can tell us a bit more about product specialists who specialize in pension funds and who specialize in annuities and endowments, etc., etc. So, very, very important. Speak to people who know. Theresa, I've got an interesting statement that Neil made earlier. Neil says, short timelines when settlement is proposed hampers the open quote new single spouse to consider these valuable inputs. So practically people make detrimental financial decisions whilst being uninformed and only looking to get the divorce done. It's a rather big decision to make without a financial planner being part of the considerations and the implications of the decision in future for the individual concerned. So what I'd like to ask you, and since you are fairly, woke, if I can really steal from the online lingo in terms of working with financial planners, Jacques, don't you dare shake your head at me. How would this work in practice? How would that timeline look in terms of saying to people in a very gentle way in mediation, let's get this person involved, let's plan this, and what are the benefits of doing that, in your opinion, having worked during your articles as a legal practitioner versus mediation?
Okay, so the first thing in mediation that I always do, let's start at the beginning. You get two type of couples that walk through your door. Only two, sorry, but only two. The one type wants to fight to the death. They will fight for, I want the purple towels, and they will fight for, I want the daisies on the right side of the driveway. The second group that you find, and sometimes you get a combination of two people that are different groups to this. The second group is, I don't care, just give her everything or give him everything. I just want this done with. Both those attitudes are what you manage in mediation. Now, once again, if anybody is interested, I know a guy that does an intro on trauma handling as well, and I borrow from him quite often. So one of the first things you do is you create a factual timeline. I do that with mediation as well. So I say to people, this is our agenda. This is our first meeting. Let's put on the list everything that is concerning to us. And when I do that, I add on there as the mediator, I ask the couple, may I please add a proper financial plan post-divorce for the two of you as well. So then we start from one end. Remember, you can get people to calm down. I use the saying, dealing with nonsense in your life that is going to continue for all eternity weighs you down. But the moment you have an understanding that it's going to end on the 31st of October, then you are okay with it. Then anybody can handle anything. So give those people a plan. These things are important. Even when someone comes to you and says, I don't care, she can have everything, he can have everything, I'm just tired, I want this done. It is absolutely right, Neil. It is imperative that they actually be guided in the direction of a professional that can help them. Now, in mediation, what's good for the goose is good for the gander. If you feel that the husband, for instance, needs actually to speak to a professional, please insist that his co-parent or co-spouse, co-ex-spouse, whatever, is also talking to a financial advisor. Make sure that you keep it equal in that regard. If you have issues, remember, in mediation, there is some fluidity. You start with the couple, but you can bring in professionals. You can bring in mommy's financial advisor and daddy's financial advisor into one conversation, not the entire divorce, into that conversation. Then we have the added benefit of a mom and a dad and two professionals in the room and a facilitator to that conversation. There's very little that can go wrong there. Okay, so this is why I'm saying it is important for this is my little soapbox for the last how many years that I've been doing family mediation, is that financial aspects are brushed over quickly. Normal settlement agreements don't cater for post-divorce planning. Normal settlements don't cater for parenting plans. Attorneys traditionally put a two-liner in a settlement agreement around the children, and that's it. They put a two-liner in about what this happens and that happens and whatever, and it's not addressed. And a lot of the times when you can get a couple past the anger, they actually still have some care for his children's mother or for her children's father. And if they can create a plan together, going forward, separate, but going forward, it reduces so much stress on our restructured family.
Then, Jacques, I want to actually throw it over to you and then thereafter to Seugnette, to go back to this idea of, making these decisions on the fly. How long is a piece of string? How long can it actually take to have a look at something like this and say it's feasible or it's not feasible? Jacques, very difficult question, but, are we talking weeks, or are we talking days, or are we talking years, decades?
Well, I think if it would take decades, we would all be in some hitman's list or something. I'm not sure it's the right one. But Mervyn, I think here the point is to start off by how financially educated each of the parties are.
Yeah.
The more educated they are, the more able they are to make a reasonable decision within a reasonable amount of time. A week, yeah? If the people are really not financially savvy, this is where I would have to take the lead as a financial planner with this and try and help and educate them to understand what the impact of that decision is. And that can take a little bit longer. But I think once you have all of the relevant facts down on the table, you should be able to have a fair decision from a financial perspective, a week to 2 weeks. If the people are listening and they want to make that decision. If they, as Theresa said earlier, if they are fighting about the daisies on the left-hand side of the driveway, then those decisions will definitely take longer.
Of course. Seugnette, from your side, you were quite outspoken about the whole silo theory, silo model. Let's call it model.
Yeah.
In nuts and bolts, if someone were to go to a client to say, look, this is what we are envisaging? Is it something that can be feasibly done, in your opinion, in the context of a mediation, understanding that these people are full of one another and they want to go on with their lives?
Mervyn, from my perspective, and possibly also from Jacques, we're in a little bit of different seats than you and Theresa, in the sense that we have a continuous relationship with the client before they reach divorce and then mediation, or mediation and divorce. So from our side, for example, for our private clients, we work on the 4 silos continuously. And if they sell a house, I'm in the first person that they say, just to let you know, I sold my house, and I then go up and I update their structuring. And I say, okay, because of this, let's do this and that. So we have an annual high-level touch of our clients, and so we are constantly working on the structuring of it. So if, for example, one of my current active clients were to reach a divorce situation, I would be able to hand over to the mediator, or it's set up for confidentiality and legality, but theoretically, I can hand over to the cent almost perfect indication of where we're at, and practically knowing the clients for all these years, what can work for them going forward. The wife is the housewife, this and this, the house and the car and the whatever assets might be worth more to her than the husband, who whatever. So from our side, we're a little bit more with our finger on top of it throughout the years leading up to the divorce. Whereas you guys, and so I think the general advice that I'm trying to get to is, depending on the type of relationship and the reason for the first engagement, would be to just have a continuous active relationship with your clients and then build that file. Because to just come in one day and you bring boxes full of policy documents, then that will take, I don't know, Theresa, months to sort out.
Yes.
Yeah.
Well, that takes one to the second question. Now, obviously, in a perfect world, both parties would have a financial advisor, preferably separate. But my wife and I are fairly corporate minded, both of us. We have the same financial advisor. Now the proverbial shiza hits the fan. Not that I'm saying it will, but let's say that happens. Now all of a sudden we are faced with a financial advisor who is perhaps conflicted, or there may be the perception of being conflicted. What is the feasibility of then saying to the spouse who is, or let's say the non-dominant spouse financially, who's now all of a sudden going to get a payout? How does one deal with that, Jacques? Let's look past gender barriers, gender stereotypes, but real talk, in most divorces, there is a financially dominant person and there is a financially subservient person. Obviously, there are exceptions, and there are many exceptions. But let's talk about my one divorce I'm dealing with now, where it is a, argument's sake, 50 million rand estate. Dad is a very, very high-powered exec. Mom has been a housewife for the last 25 years. Mom doesn't have the financial acumen, etc., etc. Where would a financial planner and a financial advisor come in at that stage?
Mervyn, it's lovely to be a financial planner in a situation like that where people are fighting over me, but realistically, it really depends on the two parties involved. If they feel that there can't be impartiality, which probably it might be, especially when we talk about a dominant and a non-dominant financially involved partner, you'd have to decide who goes where. And as a financial advisor, I have to stick with what's the best for my clients. I can't always pick the wife because she makes better cookies, or the husband because he's taken me hunting before. I literally have to step away from that, and maybe even potentially bring in another trusted advisor to help them decide where that point is. But it's key from that side in terms of me being completely impartial in terms of this. I might be able to sit with the second advisor and guide them through some of the initial decisions around investments, covers, those types of things, so that he or she has a better picture of why things are the way they are today. And it's up to me as a professional to sit and work with these individuals and figure out how to go forward from there. And then we kind of figure out how we work, which side of the divorce we end up going with.
Absolutely. I see I've got a hand going up. Let's see. Neil, good to see you back. I see that you disappeared for a few minutes. I hope you didn't miss Theresa's input on your comment earlier.
I unfortunately did.
Oh, no. Yeah.
Sorry, I tried to I logged in with my phone for a while, but I just missed that small part.
No, that's fine. The crux of the matter, Theresa, if I may paraphrase you very briefly, was, in mediation, you go through the emotions first and you give an end date for the parties. And you say, look, by 4 months from now, you'll probably be divorced. So now let's thresh through it. But thank you so much for that point. A very, very astute point that you made there, obviously from the perspective of a mediator and an attorney as you are. What's your question?
My question relates actually to the same, or it's actually more of a it's an opinion I want to hear to some extent between the presenters. Where do they feel that I'm falling off? And that is it's exactly that. For example, if you look at the settlements and you say, if you're going to take it in cash, this is going to be the implication. But now you sit with a difficult position. They are saying, listen, we've got a settlement without it's only like it's up for grabs only till the end of the day. So that person doesn't have the luxury of saying, okay, well, now you're sitting with let's say as an attorney, you're sitting with, okay, now I need to make a decision, it's going to resolve it, then all your money problems, etc., is resolved. But the financial implications it might have 10 years down the line is quite severe. So it just, what I'm trying to get to is to say, I can't agree with Theresa more about the separation of roles. And it unfortunately happens too often, especially in family litigation, where the mediator gets appointed and he's an attorney, so he kind of steps into the advice part. And I'm not advocating for that in any instance whatsoever. But what I'm trying to get to is to say, we're not looking at evaluative mediation at the moment, because the court rules in terms of Rule 41 makes an inference that it's not evaluative mediation, it's just facilitated mediation. Now I'm saying, especially given the panel of this presenters that they were today, it renders your additional abilities or additional qualifications quite useless if you're limited to not giving advice. And I understand that if your mandate says you're not allowed to give advice, that's the concept. But what I'm trying to get is to say, I'm of the opinion that family arbitration will come to light within the next few years. And to that extent, saying, okay, listen, if this is the discussion, we're not saying there's a signed settlement agreement, but if we were to let's say to just entertain the notion that if we're going to get separated by these terms, that we have a time to say, listen, we've got one selected financial advisor to say, this is the brass tacks. This is what you're going to get at the end of the month, and this is what the effect will be in 10 years. And for the husband or whoever was the more significant contributor to say, listen, here's your effect, so that they make that decision well informed about what the implications might be. So unfortunately, with the mediation fraternity and the legal fraternity not taking hands as would have been in a perfect world, he's still sitting with this animosity. And now there's agreement, listen, we'll mediate the specific point. But in the mediation, it only becomes after the question was asked, what about the children? Then they start realizing, okay, well, actually, like we've now fought for 2 years because there's numerous phases of mediation. So now we've agreed we are ready to go to trial, but now we realize it's not actually the money worth. What we want to do is now see what the implications are going to be. Is the mother of my child or is the father of my children going to be in a position to attend to the children's needs? So now they're saying, we still haven't agreed that we're not going to trial. But in order to entertain the notion that, listen, this is what settlement's going to be like,
yeah,
then you need more experts to be approved. So then you're sitting with another situation where now it's a new creation about who's going to be that expert that's going to assist you on a without prejudice basis, because there's certain things that needs to be analyzed. Now there comes more evidence out of that from previous undertakings. So what I'm trying to get to is that it's very hard to say, listen, this is not a settlement. This is not a settlement. We're in the process of settling. We need to look at viability. So it's very hard in that divorce situation to say, quickly go and get advice. Give us a week. We are, let's say, for argument's sake, accepting your settlement. We just want to make sure what's the implications at the end of the day going to be, which we don't often have that luxury.
Neil, I'd like to say that maybe what you're talking about, those timeframes are sometimes used as a bullying tactic to try and finally sort it out. And I think for what we're discussing today, let's rather say that we're hoping that Theresa would be a proper mediation and have both clients in hand, that we don't go through those elements. Yes, we understand that potentially could happen, but we are trying to find, I think for this forum, trying to find a fantastic solution for all of our clients in terms of a divorce perspective. So yes, I agree. We want time to have people and have them understand the impact of those types of things, but we have to be realistic in terms of what can and can't be done.
Absolutely. Theresa, I see you've got your hand up. I'm going to hand over to you now. I think we must distinguish, Neil, just to go back to your point, the following. You're either going to get a settlement proposal happening in the context of my attorney, your attorney, later gets shot across the bow. You've got till the end of the day. I agree with Jacques. That is a bullying tactic. And I think it would then be up to the attorney to say, listen, my client is entitled to a proper spartium deliberandi. You cannot tell us to make a life-changing decision within 1 day. We will revert by the end of the week. The second is obviously mediation, and that's where the mediator would then manage the process. And for that, I'm going to hand over to you, Theresa. Have you got any experience in this that you can share with us?
So Neil, firstly, I want to say to you in the infamous words of Michael Jackson, start with a man in the mirror. So if I want to say to you that there are really crappy mediators out there, I have to agree. Yes. If I have to say there's really crappy financial advisors out there, everybody will agree. If I want to say that there's really crappy attorneys out there, I sure as hell can agree. Yes, sorry, just live with it, Nay, okay? So I want to say to you, part of the mediation process, this is why, it's not really the forum for that, but it's one of the reasons I sort of quickly touched on that. If a properly trained mediator is involved, now how are we going to ensure in our industry that is unregulated to a degree, like you said, Neil, okay, that's a free-for-all at the moment, and member associations is voluntary, how are we going to ensure that the quality of our mediators improve? It's by which ones do you feed? Which mediators do you make rich? Which mediators do you support? If you and the attorneys on the line have found relationships with really qualified mediators, really people that have got their hearts and souls in it and that are dedicated to educating themselves, then support those people. Because part of a mediation process is exactly what you're referring to. If we get to some sort of settlement, it is still covered by confidentiality in terms of my contract. It is without prejudice. It does not matter how long who takes to put their hand to the signature, because at the end of the day, confidentiality ends with that final settlement agreement. So for me, when they are at the point we say, right, here is your settlement agreement. This is what we've agreed to in mediation. I will not allow you to sign yet. Ma'am, you, sir, please go and see your financial advisor and your attorney and go make sure that this is right. We can go back to the drawing board if anybody has a question. Because at the end of the day, this is not only your future, it is your children, it is your extended family, it is the employees that work for you. It is such a huge circle of people that are affected by a divorce. And this is the thing. You say, you are rightly so, there are attorneys out there that has huge apprehension because they've dealt with incompetent mediators or they do not actually know what mediation is. So for the select few that are actually like you, Neil, I can hear, and Mervyn and a couple of the other attorneys that I have close relationships with, and by the way, that I get my work from, okay? Those people, they will flourish in their businesses because they are embracing the next step in our legal system, which is mediation. I can give you examples out of the world in terms of where that's been used successfully. And you're so right. Family arbitration, or me and Merv are coining a phrase. Maybe I shouldn't use it before the patent is done, but we want to call it like a soft arbitration. So basically, where a couple gets to a place where they really honestly cannot make a decision, we can maybe get a panel of people together and say, right, let's decide how this needs to be done, argument's sake. But I agree with you that is in the cards. But we don't want to take away from the court system. There is still judges and magistrates that needs to see. And I'm not one of those people that say just everything needs to be mediated. Kumbaya, flower power. I believe very firmly, as also my background as an attorney, that there's certain things that needs to see a courtroom. There are certain things that needs, precedents that needs to be set, injustices that really needs to be addressed. Those things need to go to court. But mediation can take out the people that argue about the flowers on the right side of the driveway. That's the real reason.
Absolutely. And Theresa, I want to just add to that. And I think what we must all understand, and a very big flavor of the quote that I started this webinar on. And Mariki, I saw your hand. I'm going to field your question next. Knowledge is power. Knowledge shared is power multiplied. At the end of the day, we all have different fields of expertise. We all have different skill sets. And Theresa made the point, and I agree with Theresa, where she said, look, you can have a fantastic mediator and they can get these two parties who are fighting like cats and dogs to actually come to a conclusion. However, that mediator is not necessarily the one who should be typing or settling the settlement agreement. And in fact, without shamelessly trying to plug any of my services, that's one of the things I do for mediators. They'll come to me and say, look, here we've got 3 pension divisions. Shit, I'm out of my depth. Have a look at it. And I think we must all have the freedom, and if we're going to be very, very brutally honest, to say, shit, I'm out of my depth. For example, on the aspect that Jacques mentioned earlier, and going back to your point, you know, it's not favorable for someone to take their pension interest necessarily in cash, their assignment. I'm not qualified to say to someone, listen, take this pension interest in cash or don't take it in cash. I must have the freedom to say, sure, this is outside of my area of expertise, and kick that out to the relevant person. And I think that's where we need to start going as a divorce industry, saying horses for courses. You know, is it ideal for 2 attorneys to sit around a table in a confrontational setting with their clients, having a roundtable conference, trying to resolve something? I personally think it makes more sense to get a clued up mediator, but there are some people who still do it. There are some people who favor the whole shuttle mediation. Go to your mediator, go back to your attorney. Go to your mediator, go back to your attorney, and then take it a little bit further and get your financial advisor involved, get your doctor involved, get your gynae involved, get your aunt involved, get your uncle involved. Everyone who has a stake in making sure that this divorce is as fair as possible. And I suppose in that case, get the urologist involved for the blokes as well, you know, whatever the case may be. There are different people with different skill sets, and I think we must start embracing that. And on the litigation side, obviously, it's the attorneys that need to manage that, and on the mediation side, it's the mediators. I think on that note, thank you very much, everyone, for joining us today. It was a very, very informative session. Jacques, Seugnette, Theresa, thank you for giving of yourselves, giving of your time and your expertise. I learned so much from the 3 of you today, and I know for a fact our attendees did as well. And I think we will definitely in the future set up another session where we can go into a little bit more detail on specific aspects to really also assist our viewers. Guys, to all of you who were here today, it's 30 of us left. Thank you for your continued support with these webinar initiatives. I really, really do appreciate it. Thank you so much for making it possible for me to do these webinars. I really, really do appreciate it.